But thank you for joining us this evening for the International Trade and Investment Law Society's event, TikTok and Tech Export Restrictions, How Our Favorite App Got Caught Up in the US-China Trade War. My name is Poppy Doolan, and I'm the president of ITILS at American University Washington College of Law. We have an excellent group tonight to discuss the TikTok ban and related national security and trade law implications. So first, we're thrilled that moderating the discussion tonight is WCL adjunct professor and alum and the founding partner of Jacobson, Burton, and Kelley, Doug Jacobson.
Glad to be here.
Thank you. We're also pleased to welcome Neysun Mahboubi, who's the research scholar at the Center for the Study of Contemporary China at the University of Pennsylvania and lecturer in law at Penn Law School.
Thank you, Poppy.
And finally, Doug Barry should be joining us momentarily. He's having some technological problems, but he is the Senior Director for Communications and Publications at the U.S.-China Business Council, and additionally the professor at George Washington University, which we won't hold against him. Well, welcome all, and thank you again for joining us. So diving in, I've felt, especially in the last few weeks and also past few days, that it seems like TikTok is in the news every single day. And there have been updates on the ban and the lawsuit and IEPA and CFIUS and all this stuff that's related. So Professor Jacobson, can you kick us off with a little bit of background on TikTok and everything that's going on?
Yeah, absolutely. Well, thanks for organizing this. Thanks to the ITILS that I've been a big supporter of over the years. For those who may be on the line who may be students, I teach a sanctions and export control class at WCL. Have been doing so for the last 3 years, and it's been a very popular class, and every year we get more interest and more interest. So this particular TikTok, this discussion today, we are going to be focused, obviously, since this is a law school program, we're going to be focusing on some of the legal issues, but we can't ignore some of the other ancillary issues. That's why we wanted to have Doug Barry from the U.S.-China Business Council, as well as Professor Mahboubi in terms of some of the other legal issues. So I just wanted to, first of all, let me do one thing. I wanted to take exception to some degree with the title of the program, which was Our Favorite App, TikTok. Certainly, I'm not an avid user of TikTok, but I do have it on my phone because I had to see what it's all about. And so certainly when TikTok has become international news, I'm a very practical, hands-on person. I'm like, what the heck is this TikTok? Certainly WeChat, which we'll talk about, of course. WeChat is something that I also have on my phone, and I use that regularly to talk to clients in China. And that's certainly, if you do any China-related work, then you know about WeChat. So let me just, in terms of the background, so there's lots of different moving parts in terms of the TikTok issue. So I think you have to kind of step back all the way back to this past summer, where President Trump was doing a rally in Tulsa, Oklahoma. And there were some issues regarding that rally where a number of TikTok users had signed up, had used TikTok as the vehicle to try to sign up as attendees of this rally, which was controversial because it was an indoor rally and there were a lot of concerns related to the coronavirus issues. And so the rally ended up being a big flop. They were going to have an outdoor section, an indoor section, and I think Brad Parscale, who's been in the news for other reasons recently, mentioned they were going to have, hundreds of thousands of people had signed up for this particular rally, which turned out to be a little bit overstated. So then let's move forward to some of the legal issues. On August 6th, President Trump signed Executive Order 13942, addressing the threat posed by TikTok and taking additional steps to address the national emergency with respect to the information and communications technology and services supply chain. And in that executive order, President Trump declared that TikTok, which, as you may all know, and if you haven't downloaded TikTok, you should take a look at it, because I think it is important for you to understand really what TikTok is, because it really is just a short video sharing app. It's mainly, Poppy, you can jump in as far as more detail, but basically it's just a way for people to post interesting videos. Most of them are dance related or short videos, and people from all over the world post on this. So it's not just the United States, but obviously it started in China. So the issue is that this TikTok app is owned by the Chinese company ByteDance Limited. And ByteDance is a pretty well-known company in China that's pretty good size. And there were issues earlier last year regarding ByteDance's acquisition of from a foreign investment perspective in terms of ByteDance's ownership of a U.S. company. So there were a number of issues relating to this executive order. It gave 45 days for TikTok to basically divest its U.S. interests, and there were also their interest in the U.S. in Australia and New Zealand were involved, were implicated as well. And basically the issues is that the concerns were, and there's this very long memo. If you haven't seen it, it's dated September 17th, 2020. And this was a memorandum issued by the Office of Intelligence and Security at the Commerce Department for the Secretary, describing the background and the allegations regarding the national security threat. So I would highly recommend that you take a look at this if you're interested in this particular issue. It's a 25-page memo, very, very detailed. So in the meantime, in terms of the actual transaction, so there was until mid-September, so only 2 weeks ago, where there were the divestiture was supposed to take place, or some other mechanism for a sale. So as you recall, Microsoft was potential suitor for TikTok, and then Oracle and Walmart also got involved. And so it was announced just recently that Oracle and Walmart would be the acquirer. Again, details have yet to be determined, but in the meantime, so you have all these moving parts. There's Doug Berry. Hello, Doug Berry. You have the divestiture of the company to at least their U.S. assets, and then you have also in parallel TikTok then filed a complaint in federal court alleging that this whole executive order, the whole transaction, was prohibited under U.S. law. They raised a number of claims, including the International Emergency Economic Powers Act, that basically, which was the fundamental basis for the executive order. And then just this past weekend, there was a preliminary injunction issued, and then there were additional arguments because it was extended for 1 week. And then Judge Nichols here in the district court issued a preliminary injunction based upon, and the fundamental issues relating to that injunction were likelihood of success on the merits as it relates to the IEPA claim. So that's where we stand from the big picture. So what I wanted to do is I wanted to give Professor Mahboubi and then Doug Berry just a couple of minutes just to make some introductory comments, and then we will focus in on some of the more legal issues. So Neysun, why don't you take it from here, first of all, please?
Sure, thanks very much, Doug. And hello to everybody. Special thanks to Poppy and her colleagues for inviting me to join this great discussion. I'm always happy to speak, especially to faculty and students at the Washington College of Law. We've had a number of very productive cooperative activities over the last few years involving China. with Professor Jeff Lubbers, who I see as a participant in this meeting. So I'll just say hi, Jeff, even though there's no way he can say hi back. And Professor Nicola, Professor Alai. So I'm thrilled to be back in this virtual room with everyone. And I also did want to say that, the issues that we're discussing today connect to the wider US-China tensions, which I think we're going to get into over the course of the conversation. And in that respect, I did want to take a moment to just plug a new project that we've started at Penn on the future of US-China relations. We launched it last week. If you just look me up on Twitter, you'll be able to see some information about it. And as part of that project, in about, I would say, 5 weeks, we're going to highlight some next generation thinking about technology issues in the US-China relationship with Sheena Greidens, Julia Vu, and Rob Williams. So they're all much deeper in the weeds of some of these technology issues. And so I think for anyone interested in these issues, I highly recommend that you keep an eye out on our website for when we publish their papers and then for our panel discussion with them. So with that said, let me say a few things about what, from my vantage point as a scholar of Chinese law, who's also thinking a lot about US-China relations these days, what I see as the sort of key and most interesting issues pertaining to both the TikTok question and the WeChat question here in the US. On TikTok, as I understand it, and actually I should preface this by saying that with respect to both TikTok and WeChat, part of what's driving concern in the US about those two apps, and I'm not saying this is everything that's driving the concern, but it's part of what's driving the concern, is a current atmosphere of, I would say, basically hostility towards China, which manifests itself in extreme concern about anything Chinese. And so these are both Chinese apps or Chinese sourced apps. And so part of it is atmospheric. It's not, clearly, I do not want to say that that's everything, but it is at least part of the picture. And we might get back to that later in the conversation. But if we want to be more precise about what exactly are we concerned about with respect to both of these apps that somehow gets away from the atmospherics of just being scared of anything that has the word China on it. With TikTok, my sense is there are three main concerns. One is TikTok serving to censor sensitive political content here in the United States? Are there videos that teens, because especially teens are using this app, that teens want to share highlighting political issues that are considered sensitive to the Chinese Communist Party that they're not able to share? I don't know that we have a lot of information about this. We do know that there are some videos. I'm sure many people saw there was a video, I would say 4 or 5 months ago, of a Uyghur woman who, or someone who's sympathetic to the plight of the Uyghurs in Xinjiang province, that started out saying, let me teach you about how I do my eyelashes. And then it sort of turned into a quite effective message about the plight of the Uyghurs in Xinjiang province. We all saw that. Now that was briefly taken down, and rightly that action generated a ton of criticism in the US, which then thankfully caused ByteDance or TikTok, whoever's making those choices, to reverse course and put the video back up. So we know that we can flag that as a potential concern. I don't know that we know how robust of a concern it is. A second concern has to do with data privacy, right? And I think this starts to get a little bit more, our concern here starts to get a little bit more really genuinely real. Lots of young Americans have their personal information on an app that, until this deal, that personal information could well have been stored in China. And that seems to be a legitimate concern. Now, with respect to that data, we do know that that's a concern with every app. We know that's a concern with Facebook, with Twitter, with whatever other apps we all use. And so the concerns that are specific to TikTok don't seem to me to be that different than the concerns we have with all the other apps. Now, of course, because it's China and the Chinese Communist Party and all of that stuff, that adds a layer, but still these are in many ways universal issues that across the board with all sorts of different apps we need to be worried about. A third concern with TikTok has to do with their proprietary algorithm. And this is where we get really real, because it does seem as if TikTok has a really good algorithm. I am not the right person to get deep into the details of what that means or how it works, any of those things. I'm not the right person for that. But I know enough to say that it's a good algorithm, that it's what's driven TikTok's success among its audience here in the US and elsewhere. And the Chinese government itself cares about that algorithm, because they issued a regulation a couple weeks ago that basically prohibited ByteDance from selling that proprietary algorithm to foreign parties. So that's a special thing. Why would we be, apart from technological competition between two countries, and they force technology transfer in China, maybe we want to try to do the same thing in the US. Part of what we're concerned about with that algorithm is that it could be a tool for disinformation efforts vis-a-vis US audiences. It's entirely plausible that control of that algorithm means that malign actors in China could somehow use this app and its users in the US to promote messaging that somehow affects US elections or other political things. Again, these are concerns that I'm not deep in the weeds on, but I know that they're a real concern, that they're something we have to be concerned about. And the pushback, I think, on the deal that was reached and basically endorsed by the Trump administration last week is that it does nothing about the algorithm. It does some stuff on data privacy, right? There's this notion that the data is going to be moved out to the US and in the hands of the trusted technology partner of Oracle, but the algorithm remains entirely within ByteDance control, and so that could be something we might want to get back into later. Let me say just a couple things about WeChat and then pass it on to Doug Barry for his comments. I see the WeChat story as a very different story. It does not raise precisely the same concerns as TikTok, and to my mind, in some ways, the ban was a more significant event. WeChat, probably, if there are any young people on this call, you probably all have TikTok on your phone. Probably very few of you, if you're not Chinese or have connections to China, have WeChat. But if you are in China, or if you have connections with China, WeChat is a much more important app. I personally do not have TikTok. I do have WeChat, and I use it a lot. And I don't know that there's any real analogy that I can draw to the role of WeChat in Chinese life to any app that we have. Because yes, WeChat is a messaging app. And yes, WeChat is somewhat like Facebook in that you can share things on your wall. But WeChat is also the vehicle for performing all sorts of basic transactions. It's how you buy your train tickets. It's how you buy your plane tickets. It's how you pay at grocery stores. It's how you pay at restaurants. And then it's how you unlock bikes and bike sharing. There's a whole universe of social activity that you do through WeChat that I can't think of any analogy in the US. And so if the Trump administration had not been stopped by the preliminary injunction that was issued in the Northern District of California on Sunday, what would have happened? It's not entirely clear what would have happened, but the maximal version of things would be that Americans in the US who use WeChat to communicate with Chinese friends would no longer be able to use this modality that is the primary way that we communicate with Chinese friends. Chinese in the US who want to be in touch with family wouldn't be able to use it. Maybe Americans who live in China would not be able to do anything anymore. They wouldn't be able to pay for their electricity, their gas, buy their groceries, go to restaurants, because that's just the way that Chinese life has evolved, where WeChat plays this incredibly important role. And in terms of the debate in the US about whether, putting aside the IEPA concerns that drove the issuance of the preliminary injunction, the free speech concerns, which I know we're going to get back to later, the types of things that drive an interest in the US to put restrictions or even ban WeChat, to make it harder for WeChat to do business, I think have less to do with our privacy here or algorithms or disinformation or any of those things, and have much more to do with what we want to see happen in China, to be honest. There is a concern, which I think if you are thinking primarily in terms of politics in China, which is not what we're thinking about when we're thinking about TikTok, but if you are primarily concerned about politics in China and the role of the Communist Party in Chinese life, you could plausibly say it is not politically healthy to have all of that social activity all in one app, which is then easily shared, that information, with Chinese authorities. And so it's a plausible position from the perspective of being opposed to the role of the Chinese Communist Party in China, which, look, we're Americans. I mean, that's a contentious type of thing to be talking about. For us as Americans, we're not talking about our own privacy. We're not talking about algorithms that could affect our elections. We're talking about whether it's appropriate as Americans to care about politics in China. And if we do, which I think we can, but we might have to be careful about how we articulate that. But if we do, it's plausible that we would be concerned about the robustness of this app, which makes it so easy for the Chinese Communist Party to basically monitor and control its citizens. So I've gone on too long, but those are just some of the issues that I think are important with respect to both apps. And I'll pass it on to Doug Barry for his comments as well.
Well, thank you all very much for having me this afternoon. And I just wanted to make a couple of preliminary points here. And one is that it's very hard to be optimistic about US-China relations, especially if you're making a living out of it or from it, as I've been doing. And I suppose if you watch the debates last night, it's hard to be optimistic about much of anything these days. But what I want you to do is take away from the event this afternoon a big question, and that is, what kind of relationship will we have with China in the future? And realizing, of course, that there are some people in China who are probably asking the same question, but in reverse. And it's clear that there's a lot of things that we don't agree on and that we won't agree on. We're not going to agree on human rights. We're not going to agree on the prominence of the surveillance state. We're not going to agree on Hong Kong and Taiwan. And we're not going to agree on what's going on in the South China Sea. So there's a lot of things that we will not agree on. What we have been able to agree on so far, and I think it's very important that we try to continue to do this, and that is the commercial relationship, which has been mutually beneficial to both countries for a number of years now. And China, of course, is the rising power in the world. And it has been said that in the future, China will be responsible for 30% of global GDP, 30%. So it's not a surprise that US businesses are in China, want to be in China, and it's important for them to stay there. But at the same time, they're being pushed and pulled between US government requirements, which are only growing much more recently, and Neysun alluded to some of those, and Doug will certainly talk about them more. So lots of pressure. For example, punitive tariffs on goods going back and forth. Export controls are being laid on almost by the day, it seems. And then there's the expansion of those controls, even to more areas, including especially technology, but others as well. And then there are limits on investment. There are limits on border controls, where students now are having difficulty getting visas. American University, where I teach at GW, the same problem. Visitors are going to probably be under the same scrutiny. Can they get a visa to even come here if they're Chinese? Then you have reduced access to capital markets for Chinese companies being delisted, or at least the possibility of being delisted. So you have all of these things, and the entities list on the Chinese side is also growing. More and more companies could be added in the future to the entities list that China is compiling. There's an antitrust investigation that was just announced, I think, today against Google. So that's probably going to increase as well. My concern is that if those in the United States and those in China succeed in decoupling the US and China economies, then there's going to be a whole lot less business to do, and the commercial relationship will be under stress at the same time. And while there's a lot of work for lawyers now, and lawyers are playing a very important part, both in China and the United States, in trying to manage this relationship, there's no guarantee that that demand for legal services will exist in the future, especially if the decouplers are successful in carrying out what they intend to do, which is to, especially in the technology field, reduce the amount of exchange and business activities that are taking place between the two countries. So it's not a very optimistic scenario, but at the same time, and maybe we can talk about this a bit later, you know, there are some silver linings in what otherwise is a dark cloud on the commercial side. We can look at those a little bit later. Thanks very much.
All right, thank you very much. Poppy, did you have anything to add before we delve into some of the details of the legal issues?
Well, I did, on the administrative side, I did just want to say for our participants that if you have any questions, definitely type them in the Q&A and we'll get to them as they come up or potentially towards the end of the event.
Okay, thank you. That was perfect timing. So what I wanted to mention, so let's talk a little bit about, let's go into some of the legal issues. Just following up on Doug Barry, I think, for those of us who are old enough to remember, this time period in terms of kind of the anti-China sentiment is very similar to the late 70s and 80s in terms of the Japan phobia. So there are a lot of parallels to that, and I think it is interesting that you can't really there are differences, but there are a lot of similarities as well. But I think that is something just to recall. So let's delve into some of the legal details regarding both the TikTok and the WeChat executive orders. So the first thing to remember is that the first paragraph of the executive order states, "By the authority vested in me as president by the Constitution and the laws of the United States of America, including the International Emergency Economic Powers Act, or IEPA, and the National Emergencies Act, known as the NEA, I, Donald Trump, President of the United States, find that additional steps must be taken to deal with the national emergency with respect to the information and communications technology and services supply chain that was declared back in May 2019. So this actually kind of goes back to that. And we can't forget about, this is actually thinking big picture again, we can't forget about Huawei. So nobody's mentioned Huawei yet, but we have to, this all fits into the ZTE and the Huawei communications related issues, including 5G infrastructure. So, so just to repeat in terms of the executive order, it talks about specifically the spread in the U.S. of mobile applications developed and owned by companies in the People's Republic of China continue to threaten the national security, foreign policy, and economy of the United States. At this time, action must be taken to address the threat posed by one application in particular, TikTok. So let's talk a little bit about IEPA, the International Emergency Economic Powers Act. Let me just give a little bit of an introduction for those who aren't familiar with IEPA. But IEPA has been in the news not just because of the TikTok and the WeChat issue, but IEPA is the legal basis for nearly all of the economic sanctions programs that have been enacted since the late 1970s. So IEPA was passed in 1977. It was a follow-up of the National Emergencies Act of 1976. But IEPA gives a dramatic amount of discretion to the president to control economic transactions. So since IEPA was first introduced in 1977, there have actually been 59 national emergencies declared that have under IEPA. And those have included, obviously, the Iran embargo, the current embargoes and sectoral sanctions on Iran, until recently, until Congress finally passed an Export Control Reform Act in 2018. IEPA was the legal basis for the U.S. export control regime for many, many years. So IEPA is a little bit of a catch-all that can be used by the president to declare these national emergencies, and then the executive branch can then implement the various restrictions, whether it's the OFAC in terms of the Treasury Department, the State Department, and the like. So IEPA has been, there's been a lot of concern about the use of IEPA, and particularly this administration, in terms of, for example, under Section 232, that's also a similar, but obviously there's differences. But I think that IEPA has been another reason for IEPA to be brought into the forefront. Now, the key point of IEPA, and the reason why we wanted to talk about IEPA, is that the preliminary injunction that was issued by Judge Nichols on Monday addressed a very important part of IEPA, and that is the exemptions in IEPA that we refer to as the Berman Amendment. The Berman Amendment carves out certain transactions from the scope of IEPA. And Professor Mahboubi, did you want to mention anything in terms of the exemptions as it relates to what Judge Nichols, his ruling regarding IEPA and the Berman Amendment?
Sure, and I should preface this by saying that I am quite certain that Doug Jacobson has forgotten more about IEPA than I know. So I do.
I appreciate that.
I do say more. I say that as a preface, but as I understand it, those exemptions, which were driven by this understanding that the initial drafting of the IEPA did not fully protect free speech concerns, that those exemptions extend to, the first set of exemptions extend to informational materials, and the second set of exemptions extend to broadcasts. And the notion was that these categories, and they were meant to be illustrative, not defining, but these categories would be exempt from IEPA, so that the materials that fell under those categories, which, because we believe in free speech, would be still available. And I think, I understand that the interesting legal question is, where do apps and the content of apps fit into this framework? And again, I'm going to defer to Doug Jacobson on some of the case law that's relevant to this and all of that, but it seems to me that there are two types of ways of thinking about it that at a broad level are informing the debate. And one of those ways of thinking about it is really related to how we think about free speech in this country. There is a position that I would say that not everybody shares, but that has driven a lot of the thinking about free speech in the United States, which is that the more sunlight, the better. That all sorts of speech, once it's out there, it can be better addressed and better combated than putting restrictions on free speech. And of course, if we got deep into the specifics of free speech jurisprudence, we're going to find that there are some exceptions to that and all of that, but still, as a broad principle, that's something that we seem to think is important in this country. And so there is a perspective rooted in that, which is, look, we should be true to our own values, and our approach to an app like TikTok should be consistent with our values, and we should put up our values against, let's say, the Chinese Communist Party's values and see which one wins. So we should not, so this perspective would be that we should not adopt the methods of the Chinese Communist Party vis-a-vis apps. We should stay true to our own principles and let our theories about why free speech is important fight it out in the broader marketplace of ideas. That's, I'm not necessarily saying that I agree with that completely, but I think that that's a very robust perspective that I would guess had a lot to do with why the preliminary injunction was issued. A possible response to that is that apps are different. These are different types of things, and the way in which they affect and the internet more broadly, but certainly these apps, the way that they affect our social life may in fact infect our social life in some new ways that, people in my city here in Philadelphia in in the late 1700s wouldn't have anticipated. And we need to think about that in a different way. It seems to me that a plausible response to that would be sure, but we need to be thinking about all the apps in this light. We should be thinking not just about TikTok or WeChat, but we should be thinking about Facebook and Twitter and the whole lot of them, because they all raise these types of concerns. This new way in which they aggregate information and affect people's ideas about things. And there's no particular reason to think that a Chinese sourced app is any different than what's going on in Palo Alto or Silicon Valley.
Oh, Professor Jacobson, you're muted.
Thank you for the reminder. So, Doug, did you want to add anything in terms of IEPA, in terms of the, I know that there's been, certainly from the business sector, has been concerned about the growing use of IEPA and basically unfettered discretion to the president. Has there been any other kind of coalitions or other types of lobbying effort that you are aware of in terms of perhaps for the Congress to step back in here and try to rein in the president's power, not only this president, but other presidents, in the future as well?
Yes, of course, as Professor Mahboubi pointed out, the Facebook and Twitter and so forth are also involved in a huge controversy about free speech questions. They have, unfettered ability to police and monitor their own channel, and arguably they've done a terrible job because malign actors have been allowed onto those platforms, and it's debatable what effect they have had, but they certainly tried hard in the 2016 presidential election, and they're trying again. So I think it's important to revisit all of those issues, and I think Professor Mahboubi is correct. The founding fathers could not have foreseen the power of this particular technology and the ability to reach millions of people, billions, all over the planet. And so this is a whole different world that we need to understand. And the broadcast technologies have been restricted for since their inception, because there was a feeling that because they dominated to such an extent, there needed to be some regulation, fair use, fair practices of the sort. And so there was regulation, and then there was deregulation. And now the question is, to what extent should they be regulated again? I think the concern that our members have, or at least it's mine personally, is that when you start kicking out people because of their national origin, or whatever other reason, there's a certain amount of innovation that's taking place now all over the planet. And shouldn't people have access to this, arguably with some restrictions? But if you start kicking out Chinese apps, what you do is throttle that innovation and make it unavailable to people in this country or anyone else that decides to do it. And then suddenly it raises the snowball effect, where all kinds of countries start to place restrictions on foreign technology that is otherwise available to them. And then you have what's called the splinter net, which is a great word for it. And all of the costs and the inefficiencies that those restrictions will place on commerce generally. And it's going to have some very severe consequences for us and for the Chinese and for everyone else.
Thank you. So I want to just delve in a little bit more into IEPA, because I think this is very useful, because I think your point, Doug, about in terms of, and also Professor Mahboubi, I think your points are very well taken in terms of that these types of things were never contemplated, whether in the Constitution or more recently. And to put that in perspective, the Berman Amendment, which is this carve out for, we call this informational materials exception to IEPA, And this was introduced by Congressman Howard Berman, who was a longtime member of Congress in the Los Angeles area. And in 1988, he introduced the Berman Amendment, which is called the Berman Amendment, and it's named after him. And this amended IEPA to basically to allow to prohibit the president from regulating the import or export of certain types of information and informational materials. And then, so that was 1988. So this is well before the internet. And then in 1994, the Berman Amendment was then expanded a little bit to, and that was in 1994 through the Free Trade in Ideas Act. Now, just to put things in perspective in terms of how current law has not kept up with technology, whether that's in the export control area or the like, if you take a look at 50 USC section 1702, which is IEPA, there are several carve-outs. And these are the carve-outs that are as a result of the Berman amendments generally. So there are 4 exceptions in 50 USC 1702B as in boy. And it says the authority granted to the president by this section does not include the authority to regulate or prohibit directly or indirectly 4 types of activities. The first one is any postal, telegraphic, telephonic, or other personal communication which does not involve a transfer of anything of value. That's the first of the 4 carve-outs. The second one relates to donations of food, clothing, and medicine, for example. That's a whole nother topic. The third is the importation or exportation, whether commercial or otherwise, regardless of format, of any information or informational materials. And it gives a bunch of examples, including microfilm. Most people on this line may not even remember what microfilm are. Microfiche. It does mention compact discs and CD-ROMs, and also artworks and newswire feeds. So that's the third of the 4 exceptions. And then the 4th exception is also very important, which I deal with on a regular basis. And this relates to travel. Transactions ordinarily incident to travel. Now, the reason why travel to Cuba is not covered by the Berman Amendment is because the legal basis for Cuba of the Cuban embargo from the early 60s is not IEPA, but it's the Trading with the Enemy Act, which still is the legal basis for the Cuban embargo and the North Korean embargo. But that's why if you want to travel to Iran tomorrow, you can travel to Iran. There is no prohibition on traveling to Iran because of the travel carve-out for under IEPA. And the same issues that we are dealing with here for China have been dealt with quite a bit in the sanctions context. So I work quite closely with issues relating to Iran, Syria, all the other countries that are subject to sanctions. And one of the big carve-outs has been, of course, informational materials. So if you go to Iran, if you're in downtown Tehran, you're going to see a lot of people with iPhones. And the reason why they have iPhones is because the Treasury Department has used IEPA to carve out information and informational materials, including certain hardware, under IEPA and under this particular program. The irony is, this is actually a little bit ironic. When it serves the U.S. interests, for example, to promote free trade in ideas or the exchange of ideas, this was a big deal during the Arab Spring, and now currently with respect to Iran. The U.S. government wants to promote the use of apps, of Twitter, other types of social media, not only in Iran, but other countries where you have some oppressive government, to allow individuals to talk to each other to try to help organize and the like. So this is a little bit ironic in terms of what is going on right now. But ultimately, getting back to the national security issue, this gets back to the issue of national security, which is the legal basis and the foundation of the executive order. Now, I should note that I mentioned this Commerce Department memo that was dated September 17th. This was attached to the government's brief last Friday for the response to Judge Nichols with respect to the preliminary injunction. So in the Justice Department's brief, this memo was attached. And as you'll see here, there is a lot of redaction. So there is a lot of information, and this is in one of the sections is while ByteDance primarily stores U.S. TikTok user data in the U.S. and maintains a backup of user data somewhere else, some user data was previously stored in China, and there is evidence that some data is currently being transmitted to China. And so that's this information that from the national security perspective. So I don't want to understate the national security issues here relating to the app, but I think it is important, obviously, that certainly Judge Nichols, in terms of his preliminary injunction, which was issued on Sunday and unsealed this past Monday, I think certainly in terms of his view anyway, in weighing the balancing of national security versus the actual carve-outs in the Berman Amendment, he felt that the government, he felt that TikTok was likely to prevail on the merits of the Berman Amendment exclusion. So with that, did anybody else have anything else to add, or do we have any other questions?
I wanted to jump in.
To the foreign investment section.
So we have a question from Mr. Yu, which is an interesting one, that because the Department of Justice argued that TikTok can't claim a First Amendment right in hosting TikTok itself as a platform for other speech, because merely hosting a platform is not an exercise of their First Amendment rights. So the question is whether social media platform itself can be entitled freedom of speech under the First Amendment.
Well, again, these are types of issues where certainly social media platforms, servers, and the like were certainly not addressed specifically in the Berman Amendment text, the carve-outs to IEPA. But I think that Judge Nichols, in terms of examining these issues, certainly was using it's really not the servers itself, it's not the platform per se, but really it's ultimately what the use is. And so obviously TikTok is different than WeChat, as we just talked about, but certainly allowing people to exchange information, whether it's in text form or whether it's in a video form, certainly seems to me that that would be generally has been viewed as protected free speech, and probably I think most people would take the position that that would be subject to the carve-outs in the Berman Amendment. Any other questions? Or, certainly feel free to use the Q&A box down there at the bottom. All right, so I think we've talked about, anybody else want to add anything on the IEPA issue? Okay.
Just one other irony, Doug, and that is that even though the U.S. government position is sort of extend the marketplace of ideas and the value of free speech worldwide, these are basic human values, they could argue, but you better not buy Huawei's 5G infrastructure material, or you'll find yourself in serious trouble. Just another irony. I just wanted to point that out.
Exactly.
You know, I'm going to jump in on that to say, because we haven't talked as much about Huawei in particular, and it just strikes me that it's interesting that each of those cases, Huawei, TikTok, WeChat, present different kinds of issues. And if we just want to answer the initial question of, you know, why is the US government pursuing various sorts of actions against all three of them, because they present such different issues, I think it's hard to avoid reaching a conclusion that even though there are legitimate concerns on each of those three, that it is rooted ultimately in this, you know, US-China tension generally, and this sort of atmosphere of suspicion, concern about China per se, that is then, you know, reaching into all of these different apps. Because the particular set of issues that is presented by Huawei or by TikTok or WeChat, they're related, but they are ultimately different. And so I just think that's something that, you know, I've said a few times, but I think it has to remain in the conversation, which is, you know, this is within a broader political context that is new in U.S.-China relations, and is one that, as I'm sure Doug Barry would probably agree, is something that we're going to have to learn to live with. This is not changing regardless of what happens in the presidential election 5 or 6 weeks from now.
Yes, that's a good point, and it's, I think, very useful to look at the what's going on now on the legal side through that sort of political lens, geopolitical lens. There is such a thing as the military-industrial complex. There is such a thing as the national security complex, which involves very large organs of government, and you have people in those organizations that, you know, are extremely convinced that China is totally malign, but sometimes, you know, and we know the information that they have. We know what they are capable of doing. And then you ask, well, show us. Can you give us some sense of what the evidence is? And they say, oh, we can't possibly do that. It's a national security. But, you know, they haven't so far. We keep asking, show us, share with us some of your concerns. You don't have to give us all of the details, but at least give us a sense so we can build in our minds a sort of evidentiary body so that we can judge for ourselves what sort of threat is being posed here. And so far, they've been silent.
And one other thing I'll add to that is, I guess we're waiting to see what happens with the WeChat case now that the injunction's been, you know, I think that's something we don't know yet, whether the government is really going to continue pursuing that case vigorously. They might, but we just don't know the answer. On the TikTok, you know, the reporting about the TikTok deal has emphasized that some of the hawks in the Trump administration, in particular Peter Navarro, were left out of this. This was not something that they signed off on. This was more the product of the Wilbur Ross slash Steve Mnuchin perspective on China. And some of the Trump administration's allies who are very hawkish on China have been apoplectic about this deal. So Josh Hawley, Senator from Missouri, who has sort of staked out a position as being extremely hawkish on China, along with Tom Cotton from Arkansas. Josh Hawley's been very critical of this deal. He said, you know, we should force ByteDance to have a full sale of TikTok, a full sale of its code, a full sale of its algorithm. And, you know, if we can't do that, to just completely ban it entirely. So the deal that ByteDance, in some ways, very impressively managed to come up with, navigating between the, you know, restrictions in China about the Chinese government's concerns about this, and also the Trump administration's, that deal is not something that's been welcomed at all by the more hawkish elements in not only in the Trump administration, but among their allies, and presumably among you know, even Democrats who are concerned about some of these same types of issues.
Yeah, and because and just the background of that is because the deal is not a true sale. It's not a sale of the assets completely. ByteDance still will retain 80% ownership in the entity. Basically, Oracle becomes the trustee of the data, and that they would try to help to ensure that the user's data would be actually stored in the United States in a secure way. So I think that's a very important. Again, that has not been finalized, so there's a lot of this is still a lot of moving parts. So I think that's a good way, just in terms of a segue into the foreign investment issue. So this certainly gets into because the Committee on Foreign Investment in the United States is which is chaired by the Secretary of the Treasury. That is this has been part of that. This is certainly being reviewed by the Treasury Department in terms of its compliance from a national security view. And the Committee on Foreign Investment in the United States, which certainly has been around since the 70s, since the Exxon Florio law was enacted, that you know, I've dealt with for many years. It's kind of gone. There's been some dormancy. There's been some resurrection of it more recently. The Dubai Ports World case a few years ago was something that led to the Foreign Investment Review Modernization Act, we call FIRMA, of 2018, and now there are most of the transactions we're seeing, subject to additional scrutiny are relating to China, not exclusively, but many of them. And there was just a report in the Washington Post, just I think yesterday or the day before, that maybe CFIUS is going to go back to look at some other China-related transactions that were not part of the CFIUS process to see whether they should be reviewed under that, because under FIRMA and under Exxon Florio, it actually gives the U.S. government the ability to unwind a transaction that either was never reviewed or can be done after the fact. It's been very rarely used, but that power is significant, and it was used a few years ago in this wind farm case that led to a lot of litigation in the Rawls case. So I just wanted to see whether, Doug, if you wanted to, obviously foreign investment in terms of, I know you track in terms of foreign investment both ways, but certainly what's been the impact of this negative sentiment on foreign investment in the United States?
Yes, it's been devastating. In Chinese FDI in the United States, it's down 95%. And yes, some Chinese companies would love to acquire US high-tech firms, not necessarily for nefarious purposes or to carry out the China 2025 plan, which is essentially to dominate the evolution of new technologies. And again, it's sort of interesting that this is also another subtext, which is the collision of these two dominant technological powers all fighting to try to be the exclusive beneficiary from the things that are going on. But we need to also understand that some of the cooperation that takes place when you acquire another firm in another country, they bring their technology to you, and some great innovation can occur as a result, never mind all of the jobs. Now, a lot of people don't know, but the US-China trade, 7 million US jobs are supported by US-China trade, 7 million. And that's a lot. It's a lot of jobs, a lot of activity. Most of it is in the services sector. Most of those jobs are services. A good many of them are law firms, including maybe yours, Doug. And, this is actually, quite a phenomenal thing. And so as you pointed out, you have, there's 350 pieces of legislation going through Congress now that have an anti-China tint to it. And so, it's an enormous amount of legislation. It's impossible for anyone to keep track of it. Any company, for example, that might be affected by one of those things that could actually become law. And as you pointed out, Doug, the scope of these government agencies is spreading, so that they will not only be able to look at individual company transactions, but they can look at an entire industry. And that's going to change the dynamic considerably. So the powers are ever growing. And the concern is that the Chinese then will do the same. They will place all kinds of restrictions on U.S. investment, which is already starting to drop, in reply to the terrible bilateral trade situation. So then, you have the 3,500 cases that were just filed. This was the tariff issue. Perhaps some of your clients, Doug, are part of that. So the Justice Department is working overtime now, because they not only have TikTok, and they've got WeChat, and they have 3,500 tariff cases. It's a litigation fest out there, and it's only going to get worse.
Well, so to that point, my question about CFIUS is, from my understanding, under the current administration, there have been many more cases. I know in 2019, I think it was like 113 full-fledged CFIUS investigations. And it was, I think, around 8 transactions that were blocked because of national security concerns. So But my question is, in light of thinking about apps like TikTok and new technology, where is this uptick in cases a product of the current administration, or is it a product of the fact that we're dealing with national security concerns with all of these new apps and the administration is just trying to figure out how to handle it?
Well, so that's a great question, but this really is not necessarily the administration, but it's the law. So in 2018, the CFIUS law, the underlying law, was dramatically changed, and there has been a great deal of expansion in terms of the types of transactions that must be reviewed. So there are now a number of mandatory filing requirements under CFIUS where transactions involve certain technologies. There's now, it's not optional. It used to be voluntary. The CFIUS process for many, many years was a voluntary process because companies did not certainly want the remedy of unwinding. So you went in, you got your blessing of CFIUS, of the CFIUS process, and very few cases were actually either very few transactions or deals were modified or scuttled altogether. There were a few, but not that many. But now the reason why we're seeing many, many more cases is because obviously there is this requirement for CFIUS mandatory filing requirements for certainly anything now that involves any export controlled technology, anything in the defense sector, and export controlled technology can cover anything from software to hardware in the electronics area. So there's a lot of items that are just not necessarily that you would think of as really national security related, that certainly are controlled by the Bureau of Industry and Security and are included on the Commerce Control List.
Makes sense.
The only thing that I know we're probably right at the time, so I will just keep very, very short to say that for all of us who work on issues relating to China or think about U.S.-China relations, I think generally we would all agree that this current atmosphere that has resulted in these types of actions that we've talked about vis-a-vis TikTok or Huawei or WeChat, that has resulted in more stringent review of Chinese investment in the U.S. by CFIUS, it's a product of multiple factors and includes legitimate and important national security concerns, includes other things that are maybe specific to the Trump administration, and the task going forward, regardless of whether you have a re-elected Trump administration or a new Biden administration on the U.S. side, I think will be to try to sharpen our thinking about what set of concerns are the core legitimate national security concerns, what sets of concerns are more atmospheric concerns, and how can we best protect U.S. values, U.S. interests, U.S. competitiveness, U.S. innovation vis-a-vis a new and different Chinese rival, whatever you want to call them, whatever terminology you want to use them going forward in the future.
Thank you both for your response on that. Well, thank you all for attending tonight, and special thanks to our panelists. Really appreciate you joining us tonight. And for our attendees, definitely add the International Trade and Investment Law Society on LinkedIn. We post all of our events and stay tuned for future events. Thank you all again for joining us and hope you all have a great rest of your week.
Okay, have a good evening. Thanks a lot, everybody. Appreciate it.
Thank you.
Thank you.